Welcome, everybody. This is TJ. Thanks again for being here. Wow, are we getting an amazing turnout? The room is just getting jammed up with people coming in, and that's a good thing. It means the word's getting out. Hope during the call, as we get started, be sure to click that Facebook, Twitter, and Google Plus button and share this with your network. Just do a quick share. It'll send a link out. You can get other people getting on and joining you during this call. That's a great way to help get the word out, because I think when you hear what we talk about, you're going to find out there you know people that you want to share this with, and that's what we want to accomplish, okay? Because if we don't help more people, we don't get our country out of the mess we're in. So let's get started. First of all, I begin the call with a prayer, and you might want to prepare yourself in the way you're accustomed. In the name of the Father, Son, and the Holy Spirit. Lord Father, I thank you so much for the wisdom and the opportunity to explore and become knowledgeable. You know, we were told we would perish for a lack of knowledge. That means we should be seeking knowledge. We should be seeking to self-educate, and we should be seeking to grow. And we appreciate the opportunities you've presented to us to go out there and not only make a difference in our lives, but then make a difference in somebody else's life as well, because we are our brother's keeper. We should all be out there sharing this information if we believe that it can truly help them. And Lord, we just thank you for the technology you've given us, the tools, the resources. I thank you for even our mistakes, and boy, I've had my share of them. The things that we can learn from those mistakes. And everyone here has probably made some of those kinds of mistakes, and we just ask for your blessing over them, that they can be assured that you are behind them. All they've got to learn how to do is put on that armor of God and stand up like a man that you made them into be, and walk with the authority you gave them. And we just appreciate all that you've done for us. In Jesus' name we pray. Amen. Father, Son, and Holy Spirit. Okay, let's get into a quick disclaimer, and we're going to get into, we have a ton of information. I've been on the phone all day. I hope my voice holds up. We've been helping a lot of folks, and a lot of excitement going on around the country about what we're doing here. And just be assured, none of this is new, except that it's just the way that we present it and make it simpler for you. That's what we hope will be effective in helping you be successful. Disclaimer, this call is for the private members only, recorded only for the members of urlaw.org. Now, many of you are past members of livingfreeandclear.com. We also welcome you as well. Be sure you've all opted in to our website at urlaw.org to stay informed about what's going on. The conversation merely is an information share conducted as free speech and self-study of contracts, due process, and jurisdiction as they relate to dealing with law in various situations. Nothing discussed is to be considered conclusive legal, tax, or accounting advice. We are not attorneys, we don't want to be, or accountants, and we're not interested in debates with them about these issues. We are merely having a private community discussion. We do not protest government at all, although we want better, more private self-governance, smaller and more efficient government. In fact, we encourage peaceful and proper interaction between government, corporations, and the people whom the government serves. And always keep that in mind, folks. We also state for the record that we encourage everyone who owes a bill or contract obligation to keep it. But all we're really talking about here is we're trying to teach you how to verify and validate any debt that's claimed against you, or any claim against you, be a charge or whatever. And properly validating that debt, you'll find out that about 90% of what's coming against you is in fraud. That's really what we get to here. So that's kind of the end of the disclaimer, and I'm explaining what I mean by that. So you have a right, whenever somebody makes a claim against you, a bill, a charge, or whatever, to simply say, okay, prove it. And then we're going to teach you how to do that, because you'd be surprised how often they can't. And if there's no proof, there's no contract, in spite of what you might have believed. Be careful what you believe, because usually it's true. Now, listeners agree that the hosts and speakers and guests are not liable or to be held harmless for outcomes resulting from individuals' actions taken as a result of information heard on this call, recording, or from the above-mentioned websites, resources, or individual follow-up discussions. By continuing on this call, you agree to these terms. Email questions during the call to support@urlaw.org, but also be sure during the rest of the week, use our Yahoo group. Join it, post your questions there. You'll get some great discussion, sometimes some really great postings Other people are helping there. Our Yahoo Forum is an excellent tool for doing that. Again, during the call, be sure to click on that link to share with us, share our call on Facebook, Twitter, and your email links as well. By the way, later in the call, we'll take some questions and take some of your chat room questions as well. So be sure you post them there, but not right now. Wait till we get to that portion, because otherwise I won't really have an opportunity to look at them while I'm doing the presentation. During the Q&A portion, again, you'll chat your question into the chat window if you're online, or if you want to call and you want to ask a question, be sure to dial into our dial-in number and use *8, which will raise your hand and get you in the queue. *8 will raise your hand and get you in the queue. Don't do that now. Again, later on when we get to that portion of the call. Also keep in mind, we also offer this all as a replay. It instantly replays shortly after we're done. And also we put a higher quality compressed and MP3 ready for your iPod, iPhone, or whatever version on our free members page. So if you go to the free members page, you'll see the downloads there, which are the highest quality. They're a little bit edited, ready to listen to throughout the week. And keep yourself engaged in this conversation even after the call. I assure you it really, really helps. If you're not watching TV at night, but you're listening to TJ at night, or you're driving in your car, so get that MP3 download, get it on your phone, and listen to it more than once, particularly those first 2 calls in our series. I think that's really been a great outline. We've gotten great feedback about that. People really like it. Now, as you know, this is kind of a newer project, urlaw.org, because we really felt like we needed to narrow your options down to just a few processes, and it will literally be 3, maybe 4 processes. That's all we're ever really going to talk about here, because it's all you need to take care of debts, agency issues, past issues, judgments, all those kinds of things. It comes down to the simplest of things. And the one word you need to really get into your skull is jurisdiction. If there is a lack of jurisdiction, a judgment is void. I have an article on the website right there all about that. It describes it in detail. It shows all the court cases backing that up. Any judgment can be void, not voidable, it is void if jurisdiction was not properly established. And here's another word you're going to kind of have to learn, is presumption. All the time, whenever these agencies or another party or an attorney or a suit is coming against you for a credit card or a mortgage or whatever, they start off with the presumption that you are something that you might not be. But if you don't deny that, they get jurisdiction and they win. If you figure out how to go back and say, wait a minute, they never did properly establish that, you can void a judgment. So we're not talking about stuff here just to stop a foreclosure, which we will. By the way, I'm going to do a section on foreclosures tonight. But how to stop any case. And then not only stop it, though, because stopping it's not enough. You've got to win, which means win damages if they made a false claim against you. You have a right to protect yourself against false claims. That's constitutional. So, in fact, I'm going to read you something out of the Constitution about that tonight, so pay close attention. Support with that from us. You have to understand there's a very limited number of us, and that's right now it's TJ, to work with. So if you're firing a lot of long, detailed questions to me, I don't always get to them, and I certainly don't get to review everybody's documents and cases. And frankly, your case information is really not that relevant to me. What I only care about is, was jurisdiction established or not? Because if you're fighting your case based upon the facts, it's why you lose. You can't argue the facts. You can only argue jurisdiction, and you can win on jurisdiction. One very famous attorney, I heard him say, it was in the movie America, What Would the World Be Without It? If any of you saw that documentary, it'll soon be on DVD, and the book is out in the stores now. One of the quotes in there from this one attorney, and I'm paraphrasing, he essentially said, if America knew that 90% of the people in jail are there totally voluntarily, they would freak out. There would be a revolution tomorrow. And the simple fact is, I'm going to explain to you tonight exactly why that is. And it's so simple. It's such a simple mistake that everybody makes. Because, see, we've devised this system of statutes and codes and this complex stuff where we have to have an attorney for everything. The reality is, in common law, it's extremely simple. You have a claim against me, you can't prove your claim, you lose. That's all we're going to talk about. That's all there is to it. Or you claim you have jurisdiction over me, well, let me show you how you don't, and then you lose. And, I mean, I've had one fellow who told me today, he's working, and we've learned a lot from each other. He's a good friend of mine. I think he said now he's currently up to 12 cases in the last just few weeks. 12 out of 12 cases won just coming in in the first 5 minutes. There was no issue with the facts, the evidence, none of that. It was about proving jurisdiction, and therefore you can't move forward with the claim. Now, this is somebody that got away with anything, because you understand most of this stuff that people are being chased around with is fraud. It's not even real. Okay? If I harm a man, I pay. That's common law. Everything else is just a bunch of ways to keep people employed in the judicial system. Now, I'm also going to do a Thursday noon call, Thursday noon Pacific time, and that will be for advanced members and people that I specifically invite to that call only. So if you've made a donation to our website of $250 or more, we make you an advanced member, or if you're already coming in and you're having us work with you as a mentor and you've made a donation for those additional support, commonly people will pay $1,000 or $500 to get started just to have us help them work up some documents or whatever. We don't require that, but that's what most people come in with to get started. You can get real results with that. Well, if you've done any of those kinds of things, you're going to be invited to that call. Tomorrow we're actually going to open up to everybody, but I'll only take questions from those who are actually in the process of doing something. We've got a lot of great processes working right now, from foreclosures to credit issues to past judgments, and other agency issues, things like that. So we're going to answer your questions in more detail there as well, because there's just no way we can do it all tonight. And again, that will be for those who qualify at the advanced level. Find out more about that on the membership website. So again, tonight we're going to focus again on jurisdiction, and then I'm also going to do a segment on foreclosures. So for those who haven't been on the call, I'm going to do a very quick review, because it's always good to get ourselves grounded, what we talk about here. And then we'll go forward from there into some specific matters and even talk about some of your cases and things that are going on, so you can see how this applies itself, okay? I had a fellow call me today, and I get this every day, but it was just another reminder. He calls and he talked about he's been doing these bonds and A for Vs and, trying these processes and, and trying to contract out of the system and filing a claim against his straw man and the UCC and all this stuff. And believe me, guys, I've been down that road with everybody and have many friends that have. I can assure you it's, for the most part, a waste of time. And I'm not saying it's good, bad, or indifferent. I'm just saying it's a waste of time. You're not addressing the real problem. You're missing the entire problem. The problem is you keep creating jurisdiction by doing all those things. You keep buying your way in. Not the opposite. You can't claim something that's yours, and that's what people do all the time. It's like me coming up to you and saying, I'm going to claim your car because I'm a man. No, that's not what we do here. That's fraud. You can't do that. But what you can do is ask the party who says you owe them money, always, 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 always learn these two words. Prove it. And don't just try to be Mr. Nice Guy all the time. Yeah, you want to be a good person and be nice to people, but you got to be intelligent, for crying out loud. Somebody says you owe them something, even if you think you owe it, you should say, well, prove that. And then there's a proper way to do that. And they'll send you some bogus document, or they'll call with some attorney, and they'll ask you a question. And as soon as you say, yeah, that's me, you've already confessed. So let's just you've got to get this in your head. You don't want to be confessing to things until you're sure they're true. Never confess, as far as I'm concerned. Okay? So words matter. Now let's understand something. If you go into the statutory codes and you start looking up definitions, you look at these, and there's millions of pages of stuff, all these titles and, statutes, codes, regulations, whatever. Somebody comes on your property and says you got to move that thing off your lawn. You should be saying, oh yeah? Well, prove it. Well, there's a statute and code, and they'll hand you that statute and code, and you'll say, well, yeah, I guess you're right. I'm your slave. I have to do what you tell me. Or you say, wait a minute, I'm a man. Let me ask you a question. Where's the damaged party? That's it, guys. That question is the best question you could ever ask anybody. Any official comes on your property and says, you owe this, you did that. Oh, really? Well, I'm a man. Are you talking to me? Because, by the way, they're talking to a person, an individual. Those are words, and it's not the same thing as a man, by the way. And if you would answer, though, when they address you that way, you just confess that you are, and they have jurisdiction over persons and individuals. They don't have jurisdiction over a man. If you don't believe me, try to find the word man or woman in any of the statutes or codes. You'll find the word person. You'll find the word individual. Guess what? Unless you admit that's what you are, it ain't you. So that's a jurisdictional issue, isn't it? Because one of the key issues of jurisdiction is, do they have jurisdiction over the person? Well, if I'm not a person, can they get jurisdiction? Not if I handle myself correctly, they won't. Now, if this is starting to sound complicated to you, you've made it complicated. If they can't get jurisdiction over the person, and you're a man and you're not a person, can they get jurisdiction over you? No. No more than somebody can come across the border of California into Oregon and arrest me for a traffic ticket that I wasn't there for. They can't cross that border. I'm not in their jurisdiction. And there's geographical jurisdictional issues. Those of you who do your research, you'll find out that most of what the Congress and the Supreme Court and all that applies to is the United States. But what you don't look up is the definition of the United States in those codes. That definition is the 10 square mile of the District of Columbia and those other territories that aren't even in the 50 Union States. But you never looked that one up. You just assume, hey, United States, they're talking about the states, right? Be careful what you believe. And then they'll say, and then the states applies to the states. But you have to look up the definition of the word states. And when they, in their codes, when they use the word states, they're talking about the District of Columbia and the territories. They're not, it says the definition of states is those. It doesn't say the 50 Union States. Yet you keep buying into this stuff. The public fool system taught you, just don't ask questions, stand up and say your name every morning, right? That's training, that's indoctrination, and you don't ask. Yes, there's a difference between the United States and the actual 50 Union States. Big difference. That's a jurisdictional issue. What are they doing outside of the District of Columbia, you might ask? If you can go back on anything that's happened and you just start asking those questions, believe me, you shut them up really quick. So there's the person jurisdiction, there's the geographical, that can be an issue, territorial, but also subject matter. Subject matter means that the court itself has jurisdiction over that matter. Well, can I go to California court and argue an Oregon case? No, they don't have jurisdiction. That's an example of jurisdiction. But also the other way they can establish jurisdiction is they can get you to identify yourself as the person, or what I call the surety, the guarantor of the account. And once you identify yourself as such, the case is over. Everything you say after that is irrelevant. You're the surety. Whatever goes on in that courtroom, you're paying for it. That's what goes on every day, yet we don't realize that's what's going on because we're not educated. Okay? Hang on a second. I've got a little thing on my computer happen here. I got some notes. So that's the fundamental concept of jurisdiction. So all we teach you to do here, this is it. It's about proof of claim. Get away from all the garbage, the patriot stuff. You don't have to form a new country. You don't have to form a revolution. You don't have to. We're not going to have an insurrection against the United States. This system is there. It's somewhat there to work for you, but it's you that have the problem because you don't know how to work within it. You were never taught it, and that's the omission. You're taught to call a good attorney every time there's a problem, instead of having a simple basic knowledge of proof of claim and how you can stop 90%, and I'm not kidding, 90% of the things going on in the system today with that one process, proof of claim. So get away from all that stuff. I've been there. Just it might be fun and interesting. You might feel really smart when you're talking about it. The reality is you end up with bad results mostly. Few results, sometimes people pull it off. There's really smart ones, but sometimes it's a little bit of luck too. Do we have to completely step out of the two-dimensional world, the physical world that we're in? No, it's kind of hard to do that, isn't it? You might need some of those tools and resources. But what you can let them know is when you walk in there, I'm a man. You could even say I'm an American national, meaning I'm a national of the 50 Union States, not necessarily a citizen. And I'm not accepting any position as a trustee in this matter. That'll throw them off. There's a little more detailed way you do that, and you present a document into the court. You can win a court case just on that. But we're not getting into that tonight. That's a whole another process. But I will tell you this. This is why it's so important you get this. Winning your case and winning your situation, whatever it is what Benjamin Franklin was telling us when he came out of the Congress and said, well, they asked him, well, Ben, what have you given us? Now, by the way, somebody was already asking for a benefit. But what have you given us? He says, I've given you a republic if you can keep it. Now, one can interpret that two ways. One can say, they gave us all a republic. We should have a republic form of government. Problem is most people aren't intelligent enough to actually manage a republic form of government. They'd have to be totally self-sufficient. So a democracy was laid over the top of that thing. The problem with democracy is, if you look it up, it's actually a form of dictatorship that feeds on itself, and it's a majority rule. There's no rule of law. It's majority rule. So that's not a good thing either. So we have to live with sort of a combination of these things. But here's the bottom line. If you're a man of God or a woman of God, just because I say man doesn't exclude women, by the way, you were given amazing authority to take dominion of over this earth. And whether you believe in this stuff or not, I don't care. I'm not telling you I'm right or wrong. I'm just saying I don't care. What matters is the court system knows. They know. It's all built based upon it. And as long as you act like a weak wimp and you depend on somebody else to take care of your simple matter, by not simply saying, well, prove it, and let's go through this really simple process to prove it. Or you try to get jurisdiction over me. Well, I'm a man, not a person, not a fictional entity, a corporation. That's what essentially you're saying you are. Well, yeah, then they can get jurisdiction over you. Okay? So in common law, it works like this. Here it is. Here's the process. Take good notes here. Number one, if somebody makes a charge or bills you or says you did something, your obligation is to think, I need to make sure they prove it before I even open my mouth. I don't want to say my name. I don't want to acknowledge it. I don't want to work a deal. I want them to prove it. I don't care if it's a credit card you've been paying on for 20 years or a mortgage you've been paying on for 10 years. If you feel like something's wrong, stop and ask them to prove it. Okay? This is not in violation of a contract. Because, by the way, on those mortgage contracts and credit card contracts, go look at them. Did the other party ever sign the contract? And did you know that's the first required element of a contract? Then you don't have a contract. Start thinking like that. Just ask questions. All right? And if they have a valid contract, they should win and you will pay, right? But why do you think they don't ever show up? So anyway, so it starts with this. Somebody's billing you for something, making a claim against you, some agent saying you got to do X, Y, and Z, or pay this or pay that, tax or whatever. You need to give them a notice and say, wait a minute, I am a man. Start there. Start your jurisdictional question right there. I'm a man. That hurts them really. That hits them below the belt right there because they would think they're dealing with the person. And as soon as you say your name and use a middle initial instead of your full natural name, they come after you. So, no, I'm a man, and I need you to, you say I owe this thing, I owe this, I owe that. Well, I need you to prove that. And if you can't prove it, then I'm going to have to file a claim against you if you continue to make that demand. So ask them a question, tell them you're going to bill them something if they continue to do this. You need to create a bill so that you can sue them. You can't sue them over the other way around. You can't do it until you have a bill that they haven't paid. So you give them a notice. You might give them a second notice sometimes. You know, always give your brother an opportunity to respond. This falls in line with Matthew 15, chapter 6, Matthew, I'm sorry, just 15, 16 through 18. And having to do with go to your brother, try to work it out, bring a witness. If they won't resolve the issue, then take them to court and treat them like a tax collector. It's kind of funny how they say, treat them like a tax collector. Yeah, but I've thought about how I want to treat them that a few times. Anyway, so notice, maybe a second notice if you have time, and then get your claim in the court. Now, this isn't your typical claim. This is not a complaint. This is not a lis pendens. Those are statutory terms. We don't use any statutory stuff. We use simple common law words because that establishes that we are practicing common law. Okay, got it? So notice, file a claim. The claim's kind of uniquely worded. You use lowercase I instead of the capital letter I. A few things like that where you're not resorting to any titles that they've given you, that the state has given you. Okay? I, a man, demand a common law court of record. This is not a complaint, in other words. And you're not using any statutes. You're not saying revised code statutes, civil rules of procedure, blah, blah, blah. You've got to leave that all out because you're not going into that jurisdiction. Okay? And by the way, if they're coming after you and you're going to run it behind the gun, maybe they're charging you with something, you need to take a leave of court, go out in the hallway, and write a 2-sentence claim and put it in. You want to see something that will stop something from happening? Do that. Okay? And actually on the call tomorrow, we'll actually get into maybe a little bit more of a script or a little bit more of a document or something you could draft in that situation where they're coming after you and you need to stop everything and say, wait a minute, I'm not giving any jurisdiction. I'm going to write a claim and put it in. Once you do that, it turns the tables real quick. So if you don't go on the offense, you won't score any points. If you don't go on offense, you won't score any points. As a matter of fact, this is why 90% or more of the cases where you go in as a defendant, you will lose something. Here's the simple logic why. It's not because of the facts. It's not because of the evidence. It's because you gave them jurisdiction, and at that point, you went beneath them. You gave them superior jurisdiction over you, and you gave up your God-given rights. Okay? So you don't want to go below. You want to be above. Stay there at all times. Somebody mentions this, Carl Lentz. Carl Lentz does talk about this as well. You stay above them. Remember, who created government? Man. Who does government serve? Man. But if you acknowledge yourself as a person, you answer as a person or a trust or a trustee or an individual, you just reduce yourself down into the statutory world because those are titles that they use. They create the corporations. They have to deal with corporations and fictions back and forth all day long. They have to get you in their world to even deal with you. That's why they nail you. And by the way, look up in the Constitution it says that corporations have any rights. You see, you lost the second you open your mouth. And I'm going to contend the second you even brought an attorney in, sometimes that's really the problem. If they're speaking for you, you've already given jurisdiction to the court, and it's over. You're just now negotiating. You're never going to be there on guilt or innocence. Oh, you might plead guilty or not guilty. That doesn't matter. You're already guilty because you said your name as a corporate name. Okay? So notice, file a claim, make them show up for the claim. If they don't show up, or if they fail to bring a first-hand material witness, the real man, I mean a real living, flesh-pumping, blood-pumping man, put them on the stand, and if they will not testify that they have first-hand knowledge of that contract, then you win. It's that simple. You just motion the judge to rule. Not motion, excuse me. You require him to rule. Require. And do you think this is hard? Gosh, man, you know what's hard is going in as a defendant. What's easy is going in with a piece of paper and saying, here's my case. Your Honor, I need you to take action upon that. Anybody else starts to speak, you say, excuse me, are you ready to take the stand? And if it's their attorney, you say, are you ready to take the stand? Because that's all who can speak here in this situation. I need the first-hand material witness on the stand. Anything less, you don't accept. And guess what? If they can't come forth and go on the stand, aren't they now giving up? Yeah. You got a default. That's how quick this kind of case can go. It's not about the facts and the evidence. It's about standing, jurisdiction, and proof of claim. Standing, jurisdiction, and proof of claim. That's it. You keep all your cases within that realm, you have a much better chance of winning. Here's what you don't want to accept, though. If you're going into a court, you're kind of doing it the more traditional way, the way the legal system will push you to do it. You might do a complaint instead of a claim. Boy, that's a mistake. You have no standing with the complaint. All you want is a verified claim, and the word verified is very important. If they come into that court and they bring you, let's say it's a bankruptcy court, which you would not be a common law court, it's statutory, they'll bring in something called a B-10 form. That B-10 is their claim, saying, you owe me a debt. I'm one of the people who needs to collect money out of this bankruptcy. Well, if it was me, I'd say, whoa, time out. You're making a claim. That is literally a claim form. I say, well, I'm not accepting any forms here. If you can say I owe a debt, I want the man on the stand that said that I owe the debt to. Do you owe anybody a debt at any government agency? Do you owe any man a debt at Chase Credit Card Company? Well, so bring them forward. If there's damaged party, common law is all about damaged parties. No damaged party, no case, you win. And it really is. I mean, I had several examples today. People calling me in and said, you know what, when I stayed focused on that issue, I won. And when I got into discussing the debt and I said something that sounds like I validated the debt, I lost that quick. It's really amazing how quickly this happens. I have one student, and again, the story today was almost identical to that. They had gone into court. They'd won several credit card cases by staying on the issue of validating the debt. The lender never came up, never showed up, and they won those cases, sort of. And I'll say what I mean by that in a minute. They certainly stopped pursuing it and they gave up, but they ended up putting stuff on their credit and damaging their credit. You could have handled that too, but you didn't. But in this one case, the lady came in. I don't know if Kathy might be on the call, but it's an interesting story. It's a good example of what not to do. She presumed the judge was going to be on her side, and actually she had a discussion with the judge earlier. He said, everything's going to be fine. I'm going to make them bring in that discovery information you demanded, yada, yada, yada. She then comes back to the court the second time, and the judge says, hey, before we get started, I want to ask you one question. I remember this judge was all nice and helpful and, real buddy-buddy. And he said, can you tell me again why you didn't pay that debt? Was it because was there something about income or something? And she goes, oh, yeah, because I lost my income. I couldn't afford to pay it. And he goes, bang, he slammed the hammer down. He said, guilty. I fined for the plaintiff, which was American Express. Well, what happened? She had confessed to the debt by even answering a question and even answering her name, technically. But even by answering the question, she further confirmed the debt. The case was over. There was no more. She was not able to dispute the validity of the debt once she started answering questions about it. Had another guy today said that he had an attorney working all this stuff out for him, and everything was going to be worked out, and they're going to pay the debt at 1/3 the amount. There's these companies all over the internet offering you to do this. The problem is when you call that company up through one of these companies, you're now a dependent. You've hired a representative, and they're calling to negotiate the debt. They're confirming the debt, not trying to validate the debt. So he ends up on a payment plan. He can't keep the thing going. He ends up owing a lot of money to the attorney who negotiated the deal, and the debt's not. He already validated the debt. He gave them jurisdiction. Instead of saying, wait a minute, before we do that, let's validate that debt. To validate the debt is not to say you don't owe it. You never want to say that. If you think you owe it, then pay it. But if you want to at least say, well, let's be sure that this is really valid. But you'd be surprised how many times when this has to do with secondary markets and everything they do with loans, but it's all sold. They've made money on it. They've been paid 10 times over. You don't even know what's going on. You don't never even had a valid contract, actually. Well, if you know a valid contract, then you should be asking for that. They went and made money off your signature, and you never even did anything about it. Is there really a valid debt there? Is there really a valid case? You walked on somebody's lawn. Is there a valid claim there? You built a building wrong. You put a window in wrong, and they come and fine you for it. Well, where's the damaged party? If there is a damaged party, pay them. If there's not, you need to go away. These officials work for you. You don't work for them. So you get the hang of this? It's about their presumption, and you buy into their presumption, because they're going to come into court and say, well, the person known as, or the individual, or the taxpayer, or the trustee for the surety for the case did this, that, and the other thing, and you just go right along with it. Well, I'm guilty. I'm innocent. Sorry, you just confirmed that it exists. Okay? Instead of saying, wait a minute, no, time out. I'm a man. I need to know from you who the damaged party is. As a matter of fact, I'm going to file a claim to make you come to court and bring forth that damaged party. Oh, you can't do that? I win. That's the whole game here. Okay? So, that's my quick overview of that. Now, I had a lot of people this week asking me about foreclosures. I had a lot of foreclosure case folks coming forward asking for our mentoring programs and made some nice donations. We appreciate everybody that does that. It helps keep us going. It keeps us able to continue to help you. But when it comes to foreclosures, this has to do with, like I even call it the past several years, everybody's been doing this with foreclosures. They've been trying to validate the debt, which is what we've taught even in our previous Living Free and Clear programs, validate the debt and push it through and try to make them then go get a report and try to get all this evidence, but remember you're in their statutory system. It just never ends. They keep coming back with more and this and that, and they sell the note and they keep doing all these other things against you, right? And you know what? It never seems to end. Now, we've had people out in their homes for 4 years or more using some of these techniques, but it's stressful. It never ends. I'm sure there's some of you on the phone that get that. We've always been looking for that ultimate resolution. And we looked at some complicated stuff over time, and some of it, kind of worked, and some didn't, but there was never really something real clean and simple. And we think that now we're getting to that point where we're seeing some successes using a very simple thing. And one of those, this isn't all of them, this is just one, but has to do with what we're talking about tonight. You need to go on the offense and file your claim instead of sitting there on defense letting them pound you. You're under their case, under their case, instead of over your case when in a superior position. Okay? But when you go into that foreclosure court on any matter, it's like, I've used this analogy before, it's like the football team arriving, the Dallas Cowboys arriving at the San Francisco's new stadium, walking up to the stadium, and they go, oh, hey, hang on, guys, we just let you know something here. First of all, inside there, we only speak Chinese, and the referees only speak Chinese. So just in case you wanted to know that, that's called legal terms, because they aren't what you think they are. You're not hearing what you think you're hearing when they speak. Then they say, oh, and by the way, that offense, leave your offense outside the stadium. Don't even bring them in. All you can do is bring your defense in. Good luck. And when you walk in and you agree to walk in, like you walked into court and said your name, it's case closed. Oh, sure, there's going to be a game. Lots of cheering. You might get a fumble or interception every now and then, but you're never going to put the offense on the field. And you believe, though, by golly, we can still win this. This guy, this coach, this attorney I got says we can win this. Let's just keep spending money on him, and maybe he'll get us through this. When it's complete fallacy. You're not going to win. You're less than 10% chance of ever surviving that situation. It's not about Perry Mason and being right and proving the ultimate fact on the record. I argued my point. They did me an injustice. My constitutional this, my constitutional that. Bull crap. Guys, you've been living an illusion. Go watch The Matrix. You'll see what's going on. It's actually telling you this. You're living an illusion. You want to live? Come alive and go on the offense. Let me tell you what you have the ability to do. And I'm going to pull a copy of the Constitution here. This is a very simple one, but it's Amendment 7. Okay? This is a really simple one. In suits by the way, do you wonder if common law actually exists? Some people actually have argued with me that it doesn't. Well, let's see here. Article 7 of the United States Constitution. In suits of common law, where the value of the controversy shall exceed $20, value of the controversy shall exceed $20, the right of the trial by jury shall be preserved, and no fact tried by a jury shall otherwise be reexamined in any court of the United States, then according to the rules of common law. Now, what does that just say? Let's look at that again. Go look this up. Go look Amendment 7, United States Constitution. Look it up on the Internet. In suits at common law, where the value, suits at common law, common law, there really is common law, what do you know? Where the value in controversy shall exceed $20, the right of a trial by jury, that's 12, jurors coming in, shall be preserved, and no fact tried by a jury shall be otherwise reexamined. In other words, you can't appeal a trial by jury. You win a really good judgment there. In any court in the United States, then according to the rules of common law. Now, this is it, guys. This is the whole deal. And nobody's using this darn thing. They hire an attorney. They skip over all this. They go into an administrative court, not a common law court, and of course none of this applies because you accepted the jurisdiction of an administrative court. Got it? That's it. There's somebody's bringing up something about how can you give any value to something that's Federal Reserve notes. I'm not going there. That's not relevant. This is all about claims tonight. Who has a claim to something? Okay? If you just don't get off there's a temptation to get into la-la land, I call it. It's all you have to think about is jurisdiction and claims. And if they can't prove a claim, that's how you win a case. All right. So foreclosures. What are some things you can do to stop a foreclosure? There's actually a lot of things you can do, and a lot of people have done, but I'm going to give you some very simple ideas tonight. Number one is, somebody says, I need you to give me the original note and contract and all that kind of stuff, and that's good, But you don't even know what you're looking for when you ask for that, I bet, most of the time. Where's your signature on the note? They'll send you a copy of the note, but where's your signature on it? And is your signature on it if it's a copy? Okay, what are you willing to accept? Don't buy their lie. Don't buy their lie. If you think somebody's committing fraud, don't expect them to ever be truthful with you. So you can challenge the note, and that's a productive way to do it. A lot of people do that. Another thing you can do is you can use bankruptcy. This is sort of the last minute. I call this, the fire's on. You got to really slash some fire on it, some water on that thing to stop it. But what are they going to bring to bankruptcy court? They're going to bring a B-10 form, which is nothing but a piece of paper that says, yep, we're the lender. And then you go, well, look at that. They proved it. TJ, I told you you're wrong. See, they proved it right there on that piece of paper there. Come on. What you accept, be careful what you accept. There are rules to what is a trial by jury. Trial by jury requires actual witnesses on the stand, and the ruling has to come from the trial by jury. I guarantee you, 90% of you have ever been to court, had a judgment against you, there wasn't a trial by jury. So how can the judgment be valid? Well, it is if you don't stop it. Remember, all this happens because you don't exercise your republic rights. It's not up to anybody else. It doesn't say in the Constitution it's the government's duty to protect that stuff. It just means you have a right to it, but you've got to proclaim it. Nothing happens unless you demand it, and not through somebody else, not through an attorney. I mean, you might get an attorney, but listen, as soon as you go there, you're opening a lot of doors you don't want to open. I'm not saying not to ever hire an attorney. Get them for counsel, ask them questions, but you should be doing the speaking because actually God gave you a voice, He didn't appoint somebody else to do it for you. Okay? So these courts all move forward on what's called presumption and hearsay. Well, presumption and hearsay is not evidence, is it? It's not fact, is it? But they presume, because you said, I, T.J. Mars, a person, am here, and I accept, and as soon as I said that, I'm also saying I accept liability for this case. You don't even know how, you just lost. You lost it by your name. See, their presumption was just proven by your words, just like those people that lost those cases by just even talking to these people. Instead of handing a piece of paper and saying, I'm filing a claim, come over to my court. Common law court. Okay, now we open up the Constitution, Article 7, we're doing this. Guess what? It cannot be denied. Oh, they'll try to trick you out of it. They'll tell you that's patriot stuff. This has nothing to do with patriot anything, sovereign anything. It's nothing to do with that. It's a man has a right to what's in there. And you've always had that right. It's been going on for 2,000 years, that right. They didn't give it to us. They just reminded us that it was there. So what do you believe? Because if you make them believe you believe their lie, that they can presume you're a person or an individual, then they're right, and you lose. Once you go into their jurisdiction, the boss man can do to his slaves whatever he wants. And once you've agreed that, yes, I'm one of your slaves, do with me as you will, it's too late. You lost. You gave jurisdiction. But the good news is you can sometimes go back and void those things, but it's harder to go back in time to do it than to do it before it ever happens because you got some brains between your ears. So foreclosures, one is demand the note. 2, bankruptcy, try to stay away from that because there's too many ways to trick you there. But it's good to stop things temporarily. But until you file your claim, not much is going to happen. Here's a third thing you can do. Our ministry is an SSM ministry. It's a private ministry. It means we didn't go get a corporation soul or a corporation or go to the Secretary of State and beg for anything. Okay? This is TJ, by the way, whoever's asking. This is still TJ talking. We don't have to go to get permission from Caesar. We are a private ministry. Every church in America should be a private ministry because as soon as you put Caesar between you and God, who is your God? That's literally what the Bible is telling you not to do. And I don't care what today they have these. I have a good friend who got off on the idea that the way to do a private ministry was to create a corporation soul. And I said, wait a minute, aren't you going to the state to get that? Yeah. And don't you have to register every year? Well, then they own it. It's theirs. You may be telling people to get out of a 501c3, but now you're telling them to get into another corporation. They're another dead entity. not our ministry. And here's the beauty of that. Anybody who feels like they might have a mission in life can form a 508 nonprofit foundation or ministry. Anybody can do that, because in the private, their statutes and codes don't apply anyway, unless you hurt somebody. That's different. But here's the other cool thing about this. What we found is, and thank goodness it's another group that does a lot of foreclosures, they reminded me, I knew this, but he reminded me of it recently, that once you go in, you transfer the title of a property into a 508 private ministry of some form. Guess what? They won't foreclose on it, very likely. I can't say they won't try, but it's very unlikely they'll ever do it, because now it's owned in the private, and also it's a nonprofit. They would have all kinds of problems going against that. So if you set one of those up, and then you put your property into it, but you better have good intentions too. You better have the intention of using it for a good purpose. Well, I'm not doing this just as a plug, but we do help establish those for people. And if you want questions, you can email me. We'll give you the details. Normally there's a donation involved of somewhere between $500 for just a basic setup, or if you want consultation and some work with something you're doing, it would probably be about $1,000. It would be a recommended donation, but it's not required. But that's typically what people are willing to do. And sometimes when we win a case, they give us a tithing back of 10% of the winnings. Okay? But then you process everything through your ministry, and you start living in the private. Private's a good thing. But no, I'm not telling you that, by the way, for any tax or legal advice. I'm just telling you, when you're in the private, you've got a lot of benefits, and it's a private ministry. So, if you have any questions about that, feel free to email. Just send that to support@urlaw.org. So there's a few ways to stop a foreclosure. You do a challenge, which is limited. It'll do it for a while. Title the property, transfer the title, be a warranty deed into a ministry, or use bankruptcy, which can be a snake pit. But the big one, this is really what you need to do, is get a claim in. You'd be surprised when people file a lis pendens and a foreclosure how quickly they run. But the problem is with lis pendens, you're going back into the statutory system. With a private claim, you're still having the same effect, but you have a private claim is a much stronger case. And once again, you can notify all the parties after you file and say, okay, you got 21 days to bring forth your proof, or I'll bring you into court and you can bring it there. Which way do you want to do it? And that's all this claims process is. But it's on the offense, not on the defense. The defense can go indefinitely. The offense can put a time limit on it. Say you got 21 days. Oh, you don't show, Your Honor. I require you. You don't ask. You don't beg. You don't motion. You don't plead. You require, when you are a man in a common law court, that the judge rule. And if there's nobody disputing it, what's he going to rule? Bang, you get a judgment. Now, what do you have when you have a judgment in a foreclosure? You got a document that's a negotiable instrument. You don't believe me? Go look online for judgments, selling a judgment online. Look it up. Look how many companies will buy that paper from you. Okay? And especially if it's from some big bank with lots of money, or in a law firm with a bond, because you can sue the law firms too. So imagine that. Imagine having a judgment, and then you go back and say, and by the way, this is why they don't want to go there. You can go back and say, well, you said I owed you this $300,000 mortgage, but man, I just won this judgment for 3 times that because it was fraud. Right? Well, what do you think you're in a position of? What do the scales of justice look like now? 3 times the value on your side, and they got this little piece of paper over here, which they never validated. What do you think? Which one has the most weight? So you can say, well, I'll tell you what. We're either going to try to collect this, or you can say, I'm going to make this easy for you. I'll just call it a day. You just completely wipe out this mortgage, take all the credit stuff off my credit. This is how you clean up your credit. You got to get a claim. You got to win a claim, because now you can force them to remove it off your credit bureau. And now suddenly you got a clean credit file. You've got rid of their debt. They never validated it. They never brought a valid contract. They made their money. Don't worry about them. Trust me, they've made it. And you've done actually the correct moral and ethical thing. Because, yes, you should pay your bills. But if there's fraud involved, should you? You have a right to ask. You've got to get it in your head. There's a difference between a real debt and a fraudulent debt. If a man is harmed, they give you their house and you have to pay a note back to him, and you don't pay him, you've harmed him. You've taken something from a man. But when it comes to these fictional entities, they create their money off your signature. They're making money many times over, and you don't get a piece of the profit. You don't have to feel bad about asking them some questions, verifying the debt. You're not refusing to pay. You're just challenging their authority and jurisdiction. I don't care whether it's a government agency or whoever it is, at any level. You have a right to ask. And you'd be surprised what you find out when you start looking, guys. I mean, I didn't think this stuff. I thought for a while, oh my gosh, I just need to pay my bills and be a good human being. I said, well, that's true. But are these things fictions? Are these things just something they created out of thin air? Absolutely. And they use it fear and evil, in my opinion, because fear is evil, on earth, to control you. Yet there's nothing real. There is no money, not since 1933. So how can there be any debt? Okay, so that's my dissertation. Foreclosures, great, many ways to stop them, but not only stop them, to go in to win. We're not here to play anymore to stop a foreclosure. We're here to stop it temporarily if we have to, but we're here to win. And that's what you need to start thinking like if you're dealing with foreclosure or know somebody who is. Okay? If you're dealing with any infernal revenue agents or anybody like that, I'm not telling you not to pay your taxes. I'm saying if you're a taxpayer, pay the taxes. The question is, are you a taxpayer? And did you earn income that qualifies for taxes? If you did, pay it. But what if you asked a few questions and they didn't verify it? No, the question is, do you have the cojones to actually ask the question? And it's just a question. How much harm can you do by asking a question? A lot of people are afraid because why? You've been conditioned to be afraid. They spent a good part of the last 100 years conditioning societies to be afraid of something that doesn't exist. A false god. Guys, even if you don't do this stuff, you're sinning because you're bowing down to false gods. Don't believe me? Fine. Look at the result and then ask the question. Okay? All right. Now, that's my overview of the coverage tonight. Hopefully the foreclosure part helped you understand. If you get that claim in, that's one of the best ways to stop things. But also, we're not just here to stop, we're here to win. And you should be too. No valid claim, you have a right to ask for that. That's been since the caveman days, that's the rule of law. Nothing's going to change it either. They can change the statute tomorrow, but they can't take away your God-given rights because nobody's above them other than you and God. So remember that. They can say they do it, but they can't really do it. All right. Questions. You got questions? Start posting those on the chat window. I'll be glad to just hit those as they pop up. If you're you want to put yourself in the phone queue, press *8, and we'll take calls here for a while, or just take questions that are coming up in the queue. Here's one looks like came up. When in court, how should we respond when asked, "Are you Mr. XYZ?" Your response would be, "I'm a man." And actually, I've got a really good one that somebody gave me that they actually been using in court. It's working very well. But I don't have it ready, but it's a very simple sentence. I'll have it for you next week in terms of something you could say that more or less goes into a little more detail, and you could have it scripted so you could just read it. But you'd actually put it into the court, too, as evidence so that it's not even questioned. But really, in my opinion, if you just say, "I'm a man, I have a claim before this court, I need you to act upon that claim." If you're actually speaking in those simple terms, that's how you win. It's when you start playing statutes and codes and saying I'm smarter than these attorneys whose language I don't even understand, that's when you're a fool. You're just being a fool. You may think you're smart. There's no point in even going there. You don't need to prove anything. You're a man. They're inferior. They're fictions. They're entities. Those are persons. Those are individuals. Those are corporations. An attorney is a title. It's not a real thing. The judge is just a guy with a wig and a cross-dressing dude at that. Okay? I mean, just kind of think it like that. I don't mean to be insulting, but I'm just trying to get you to look at it, what's going on. It's all costumes, makeup. You know? As a man, you have absolute authority. If you haven't read your Bible lately, and I need to read more of it all the time, please do that. Whether you believe it or not, don't even just read it just from the standpoint of what the legal instructions are in there. It's all in there. It's a manual. And that might insult some people and say, "Oh, it's a spiritual guide." Yes, it is. It's many things. It's many things on different dimensions. But it is absolutely a guide to law that can't be changed. You can't change it. You can't change it anymore. You can change gravity. It is what it is, whether you believe it or not. Too bad if you don't believe it. Okay? Any other questions popped in here? Okay, here we go. Okay, how does a man or woman fill out a court's form to fill out a claim? Simply cross out defendant, plaintiff, and reword the form? No. I use a letter. I mean, it's just a format. I even changed the name of the court. I use the federal court versus if it's a federal court case, versus the U.S. court, because there actually is a federal court within every courthouse. You don't need to use their forms. In fact, you should never touch anybody's forms. If you want to file a tax return, send them an affidavit. Ask them a question first. You fill out their form, it's a confession. Every form is a confession. So when you you fill out one of their forms and it says defendant, plaintiff, you've already confessed. So no, don't use their forms as much as possible. You put in your claim, which is a simple one-page document, and it simply says, I am in, versus, not even versus, just a line that says, Joe Smith, wrongdoer. Purpose of claim, fraud, usually it's trespass, because anytime somebody's trying to affect your property, they're trespassing on your property. Your property is everything of your being, your wife, your kids, your house, your car, your income, anything that removes your property from you. Everything is property that you create. So you just simply have that header. You say claim, trespass, whatever it is. There's a couple different ways you can put it. And then you simply bullet point. I, a man, claim that this person here has made a claim against me, and I claim that they are committing trespass and fraud. Typically that's the case. And a couple other things you could put in there. And then you just put that simple one-page document in, and people get them in all the time. And they'll try to say, well, who's the plaintiff? Who's the defendant? Not in common law. There's only a man and wrongdoer in common law. See, you got to use the right verbiage. No name. You don't even put your name on the top of it. They'll have you fill out a separate form, which might be required to identify the parties. That's where you put your full first, middle, and last name, upper and lower case. You never use initials or titles or abbreviations, because those are titles. Those are statutory. If they require you to put your name somewhere just for the record, you do it. But I'm just saying, as far as the actual document you're putting in the case, it's a simple one-page claim, properly written. And I just had somebody call this morning, said they got hers in, no problem. The simpler it is, the more likely it is they'll record. Oh, well, let me address this issue, because this seems to come up a lot. Well, what if they won't file my papers? Guys, the reason they're not filing your papers in most of your cases is because you're putting in papers that don't make any sense. And you're in a statutory situation where you have no rights. That's why they can hammer you. And you think, well, I got my rights. No, who's I? You're a person. You have no rights. You're an individual. You have no rights. You see what I'm saying? But as a man, once you get that claim in the file, you can add any documents you want to it. What they're telling you is, this happens a lot. They'll say, you can't record this stuff here. It's frivolous, whatever. They'll tell you, we don't take that Patriot stuff here. But if you have a case open, you're only adding evidence to your case. They won't stop you from doing that. So once you have a case going, you put everything you want in. You want to put affidavits, you want to put stuff that's not even relevant in there, it's up to you. But you want to get it in a public record? You're worried about some affidavit you did years ago you never got in the record? Well, put it in now. Now it's in the public record. Once your case is open, you can do anything. You can do that. Just open a small claims case and do it that way. Get documents in. Okay? If you ever had problems getting public documents recorded, open up a case file and watch what happens. You can do it. Okay? So now, I put my home in a trust. Do you think that I need to put a claim where the house sits for the land? I'm not sure I understand that. Put a claim where the house sits for the land. You're going to have to clarify for that. I'm not quite following that. Somebody says about getting a land patent. That could be a useful process. Not an easy process for most people. But the simple fact is, once you get into common law, you make a claim and nobody disproves it, it's over. You've already proven it, because they didn't dispute it, and they can't. Does a man or woman need to pay a fee to file a claim? Good question. I would say that no, you don't have to, because that's a statutory thing. And you ask. There's actually, I've got a letter that I give somebody if they need a little help with that. Generally speaking, it's easier to just pay the fee and just get in the court. But if it's cost prohibitive, you have to simply, they have a form that you can fill out saying, I'm a pauper, I can't do it. And by the way, if you're a man, can you earn income? Because isn't that a statutory term? So when they ask you, what's your income and why can't you afford this, go ahead and fill out their darn form. How much income do you earn as a man? Because income is a legal definition. It's not all things that come in. See, every word has a meaning to it. Let's see, what other questions have come up here? Why would a man fill out a pauper's forms? I agree. I would avoid it at all costs. There may be some situations where it's the only way you're going to get it taken care of. Just be careful. That's all. You might have to for the sake of, you're communicating to an entity, so you kind of have to try this. Even though you don't want to speak their language, you want to be a complete idiot when it comes to their stuff. You can tell them. You can look at the form and say, I don't understand this. I'm an idiot. I don't understand what this means. And they'll say, well, it's to fill out the form to pay. I said, no, I'm a man. How does it apply to me? And you can just, literally, the best thing you can do is never to be an expert, be an idiot. Literally, if you just look at the old version of the word idiot, it's actually a thing you want to be able to declare in their courts, because then they can't get jurisdiction because you didn't accept and understand their charges. You see how this plays out? You just don't want to play into their stuff. Those words they ask you are not what you think you hear. Okay? Keep popping those questions in. If you've got a phone question, I will open up *8, get you in the queue. And by the way, if you're any of the people out there that I'm working with on a case, I want you definitely to get on here so we can maybe kind of clarify what's going on. We got some people coming in, so let's go here first to, looks like somebody in Southern California. You're on.
Hi. TJ, I would like to talk to you, if possible. I was trying many times to contact you, always without luck.
Okay. What do you have going on?
Can you, I would like to talk privately. Can you call me?
I'll do my best. I've got like 10 people on hold all the time, and I'll call people that are in our system first. But is this Art?
Okay.
I recognize you.
Today. Let me ask you a question that I can now.
Yeah. Right to the point.
I'm trying to understand what you offer. Suggested donation is $250, and you make what, church, or what do you do?
For $250, what we similarly are doing for people is giving them access to our private members page and a group call, and a 1.5 hour consultation with that. If it goes into something where you want more detailed stuff,
if you want one-on-one consultation, can you call me?
A formal consultation, yeah.
Sorry?
Yeah, I mean, we'll initially have a quick word with you, but then if you want to get into a full consultation and you want some additional just kind of direction, we can start with that. It doesn't do any document preparation or anything like that for that, but it does get you off to a good start, and it gets you access to some of the documents we have on our advanced page.
I'm right now in court, and the trial starts tomorrow, so...
yeah, I can't make any assurances we can do much in that short of a time. It takes preparation going in. What kind of a case is it?
Criminal.
What's the matter? What's the nature of it?
Battery, they charge.
Okay. Was there a harmed party?
Injured party, you say?
Yeah.
They claim there is.
Okay. Well, I think for the short term, I mean, there's just not much prep time to do this. All I can give you is I'll give you a quick suggestion is say bring forth, say I'm a man. I'm only here in that capacity, and bring forth the damaged party so I can compensate them before we proceed. That's all you can do.
They're not interested in paying. Tell me, please.
Are you asking them or telling them?
When can we talk?
It would probably be later tomorrow. I'm pretty booked up in the morning.
Okay.
Yeah, just try to contact me during the day. We'll see if we can hook up.
In the evening, I'll be sitting at home waiting for your call.
Well, you'll just send me an email with your contact information so I can give me a reminder, because I get so many emails every day right now.
Give me the email address, please.
Just support@urlaw.org.
Support
at urlaw.org.
At urlaw.
Our website, yeah. Okay?
Okay. Thank you.
All right, Art. Thanks.
Bye.
Okay, let's get the next caller. We got somebody in Central Coast, California. You're on.
Hi, TJ. This is Tina.
Hi, Tina.
Hi. A couple of things. I like what you're talking about in the common law. If you've got someone, like I have a friend right now who's dealing with a foreclosure case with Aquan, and I've been helping her as much as I can with my knowledge as I learn it. But she is, I would say, she's not mentally unstable at all, but she's just said, Tina, I can't do this. I can't go to court. I can't fight anymore. I just want to give them a settlement offer and try to get a loan. She says, I can't fight like you can. She said, I need to focus on my career. And, mentally there are a lot of people out there that just, they don't have it in them. Can someone who is a friend of theirs who maybe has a little bit more strength go in with this common law, what you're talking about? If they end up in court, can someone who's a friend who can speak, can they speak for them or not? Because everyone's entitled to a counsel. Counsel doesn't have to be.
They have their words have to be spoken.
Okay.
But you could be their friend giving counsel. But you can't speak on their behalf, or you're now in their courts. The only person that can do that is an attorney that I know of.
Okay.
In that situation, you would have to say you're going to have to. If the judge will allow you. Remember, if you're in their statutory court, the judge can do anything he wants.
Okay.
Remember the rule. You think there's rules? There's really not. So.
But if they do this claim like you're saying, pretty much would they most of the time, like if they followed your process and paid a donation to get help going to Stockton, would they likely end up in court or perhaps not?
It's possible not. They may offer a settlement before you get there, but you better do it. You better do it as if there's absolutely a 100% chance that you're going to get them in court. And all you're going to have to do is say one thing. You don't have to say a lot. You put papers in, you put your claim in, and say, Your Honor, I'm here because of that matter right there, and I require you to make them to bring forth their witness. Oh, they don't have a witness, Your Honor. You know what you need to do, and that's about it. I mean. You're not in statutory land anymore, statutory and code land. That's the matrix. You're in real common law land, common sense, and I can assure you, I know this. It's very intimidating because everybody's used to being beaten up. Everybody's watched all the TV shows. They've watched the show, where the defendant comes in and he ends up going to jail, and they don't want to do that. But this isn't jail. This is simple common sense law. You say you have a claim, you can't prove a claim, you can't bring forth a proper claim, then there is no case. Jurisdiction is done. Jurisdiction is the easiest way in the world to win a case.
Yeah. I want to tell you a little thing, too, that you'll enjoy this because I've got a civil case filed against my lender, and today we defaulted them, and I have it a proof of service because I used a process server through a legal group to file, to serve them. Today they filed to set aside my default on them, and they put in there that I filed it one day before the 30 days because they weren't served until the 10th. Well, I have proof that they were served on the 6th, so they are actually lying to the court right now. Saying they weren't served until the 10th, 4 days after they actually were. So you really have to read everything that they put in.
Especially in statutory court land.
Yes.
Not in common law court. It's real simple. There's no statute of limitations. There's no civil rules of civil procedure. There's none of that, because civil means civil law.
I'll be coming to you for that on another claim once I'm getting through this one. But I just thought it would be interesting for people to see that you really have to look at everything they do, because they will come into court and they will lie. Oh,
they are lying. Listen, if your first relationship, the first day you had with them, started out as a lie, which it did, they said there was a contract and there never was because they never signed it.
Mm-hmm.
That's simple common law, contract law. Everybody knows it. If they didn't give you full disclosure that they're going to go out and make all this money and then not reward you for generating the money, because that's what you did, they didn't tell you a lot of things. Non-disclosure violates the contract. That breaks jurisdiction. The wrong parties breaks jurisdiction. I mean, there's a whole bunch of ways to do it if you understand it. It's not about all those facts and details and statutes and codes and procedures and motions. It's not about any of that. It never is. It's about whether you're continuing to give them jurisdiction to keep doing it.
Yeah.
As long as you keep playing the presumption game with them, they'll bat you around like a tennis ball till you quit. The only reason they can get you to win is through confession or you quit, which is a confession. So, and most people don't realize how easily they do that.
Mm-hmm.
So you've done great, and you understand it. The hardest thing you'll have to learn about this process is how to unlearn and stop using all those fancy words.
Yeah.
Yeah,
it's really interesting. Well, I'm just going to go and file now and prove that they've got fraud upon the court again. So just wait.
Sounds like you got a pretty good case there as far as the statutory thing, because they lied, and and you just need a rule for a motion for summary judgment against them, and then put your order in away.
We've done that already, and they're just pretty much fuming right now. And we also, the other thing they did, which this is another thing for people who are already in this arena, and from what you're saying, I think it would be good to do your way beforehand, try it first. But when they moved the case from state court, which we filed into federal court, they did not move the whole lawsuit. It was 900 pages. They only moved 75 pages to it. They missed off all the exhibits.
My lawsuits are one page.
Yeah.
Anyway,
so
I can't even.
Another fraud upon the court.
It's all fraud. Remember, once a fraud, always a fraud. It's void ab initio, void to the beginning. So everything after that is fraud too. No matter even if you think it's fraud, it doesn't matter. Everything they're doing is a fraud if the contract itself. See, and everybody gets off the subject of, wait a minute, it's just about this contract. It's about one document. It's not about the 900 pages.
No, it's about, there's one main thing in there. We just threw some other stuff in there, but there's one main point, and that's it. And they can't answer that one main point.
The idea with this whole statutory code system isn't for justice or truth or anything. It's about feeding itself. It's a voracious monster that exists out now. We've let it get out of control. This lawsuit legal system where they can just keep the thing going for as long as they can keep it moving. Everybody's making money except you.
Mm-hmm.
And your energy, the human being, is the only thing that creates the energy that keeps the machine going. Go back and watch The Matrix. It's exactly what they were telling you.
Yeah.
Your batteries for the machine until you wake up and figure it out, and then it's it. You unplug yourself.
Mm-hmm. Yep. No, you're exactly right, and I'm truly loving all the learning I'm doing. It's really amazing. I love it.
Good.
I'm never going to stop.
Good. Well, you can't, as long as you're alive. If you want to take a vacation from this, then you're dead. So.
No vacation. You've got to keep learning.
All right, Tina.
Keep
thank you.
Up.
Thank you. Got some more callers in the queue. I want to try to get to those. QT judgment has been awarded. Alleged parties have filed a corporate assignment of deed of trust with no action pending. Is this strategy of use? You have to explain that a little bit to me. A house sits on, because it sounds really like some of that statutory Chinese to me. I mean, no offense to Chinese, but I still don't understand them. I just like their food, okay? So I just don't, know what that means. But maybe you can explain it. Our process is always simpler. Our house sits on a certain size plot of land. Should you claim the land to help protect the house? I'll believe the stake lenders claim the home correct. This matters what they're doing. What's going on? Are they making a claim? Are they foreclosing? Are they saying you owe them anything? If they're not even foreclosing, they just say you owe them a bill. That's a claim. Go ask them to prove it. You see, you're getting into this statutory land, and all these words you're using here, I don't understand. Protect the house. What does that mean? Everything is your property. Your real estate is your property. But when I say property, I'm not talking about real estate. It could be interest in a trust that you are a shareholder of, or interest in a corporation. It could be anything you created. It could be this recording I created tonight is my property. Anything that's of your labor is your property. Your income, your alleged income. They call it income. I call it compensation for labor. And so on. It's all your property. If they're trying to impact your property, that's a trespass. That's the first violation of common law. That's all you got to get them for. It's easy It's easy for you to prove, and very hard for them to disprove. But they have to come and sit on the stand. Anything less is not satisfactory. You don't want a default. You don't want them not to show. You want them to show and put them in front of a jury. The jury is the judge in a common law court. The judge is an administrator. That's all. All right. How can a conviction make a claim? They don't. They make a complaint. It's a different word. Okay. How can a man or woman go out and work for themselves without using a permit or license or without being harassed at the same time? Okay, great question. Did God require you to get a license or permit to exist and to produce your labor? Maybe you can answer that one yourself. And if they ask you, well, you need a license or permit for this X, Y, and Z, I said, really? Bring me the damaged party, and then I'll be glad to help you with that matter. They can come at you all they want, but once you've done it once or twice and they know who you are, they'll leave you alone. The only way you're going to stop them coming is when they see that you're a man and not or a woman, okay, a real man or a real woman. Don't use the word real, but just a man or woman. Once you let them know and you start asking the questions instead of responding to their questions, because your temptation is to answer. Don't answer, ask. Jesus always gave a parable or he asked a question. Do the same thing and look how much power you have. He gave you the same authority. You just got to start acting like a man, okay? Now, if you want to do a job or industry where they require some sort of license or whatever, yeah, it can be a little bit of a trick, but you can still ask and say, well, can you show me where in common law that's required? Now, if they decide not to hire you for that, are they not damaging your property, which is your potential for labor? See? You got to start putting it back. Always put it back in the form of a question about a claim. Okay? Yeah, it might be inconvenient at times, but the convenience is a benefit, and the benefits are what Caesar gives to put people into slavery. Yeah, work for yourself. Be your own boss. That's absolutely right. Be a contractor, but don't even call yourself a contractor. I'm just a man. I can help you do this. Pay me. Do I need to fill out a 1099 form? Well, there's no place on a 1099 form for a man. How could I do that? But I can certainly accept compensation for labor. And by the way, those words are in the IRS code. They actually have that exclusion. They actually have some hints in there. There really are some hints. Yeah, I see why the semantics, why man wants to be his own boss. I got some people on the line I'm going to take here in a second, so slow down on the chats. So I want to make sure they're actual questions. But TJ, public service don't even know what a man or claim is. That's too bad for them, isn't it? When I go into their court, I don't know what their language is either. That's not my problem. You see, you got to get it right. You're going into a foreign country. You don't have to know their rules. You can say, I'm ignorant. Don't do anything to me, and they can't. They can't get jurisdiction over you if that's what you are. You'll get more harassed by not getting this stuff down than you'll ever get by doing it any other way. All right, Southwest Florida. There we go. That line's unmuted. Hello? Hello?
Hello.
Are you with us? Yes.
Hello.
This is TJ. Go ahead. Can you hear me okay?
Hello.
Yes, I'm here. I'm here. I hear you okay. Are you muted or are we muted or something? I think I'm still here. Maybe you have to redial in. I got some kind of connection issue there. Go to the next caller. It's such a long list. It takes me a while to get through it here. Let's go to someone from Texas calling in. The great state of Texas. Who do we got?
Hello, this is Willie Johnson. How you doing?
Well, hey, Willie. How are you?
I'm doing real good, man. I got one or two pieces of information I need you to help me with. There are a template for filing a claim.
Yes.
An example or something I can get from you.
Yes, that's what we're talking about. If you do, it's one of the advanced options, and we give you some. We don't like to give the template out with actual consultation and working with you on it because it won't by itself. It's not a there's no such thing as a piece of paper that wins a case. Yeah. You got to go with it, and as a man, understand what you're doing with it.
Mm-hmm. Okay.
Okay.
Well, you know, I paid $5,000.
Pardon?
You know, I paid $5,000.
Well, not to this ministry though. I mean, that's a different. That was some time ago for a different product or service. But we can talk about that one-on-one.
Okay. All right. Well, okay. And what about?
Yeah, it's not. It's not me. I didn't own that company. That was a company.
Okay. Well, we just need to talk about it.
Yeah.
What about a response for a more definite purpose to amend the complaint? Is that something you?
Well, it sounds like foreign language statutory stuff to me.
Yeah.
What do you want? What are you trying to do?
Okay.
I want to know what the problem is.
Well, we filed a complaint against Bank of America.
You have?
Yeah.
Okay.
And the attorney, in the beginning they give you a flurry of motions for whatever. So the motion is they want a response for a more definite purpose to, in order to amend the complaint.
So it's a complaint, and you're a complainer, and they're telling you need to give a more definite response because we don't understand what you're whining about. Because that's what complaining is whining. Yeah. And so see, you're in the game now. You're in their little matrix.
Yeah. Okay.
They can start spinning you around.
Okay. Well, I just want to, be able to file it if possible,
Sure.
And then we can possibly have them to settle. Because they are definitely in left field.
Well, the question is in every case. It isn't. I don't care what kind of stuff they did. I don't care about MERS and selling the mortgage and fractionalizing and slicing it into a pizza or whatever you say they did. Uh-huh. What I do care about is are they making a claim? Have they come with a living man to go on to take this testimonial stand and prove their contract is valid?
Okay.
They haven't done that, have they?
No, they haven't.
This is why every foreclosure is voidable.
Okay.
But nobody ever does it because they get off on all the wrong stuff, and the attorneys just keep them spinning in circles. Keep spinning those plates, spin those plates, spin those plates. You can win, trust me. Keep paying me my retainer. You can win. Keep spinning those plates, and then you lose your house. And it's like 90% of the time that's the way it goes.
Well, it's pro se, but that's why I'm asking for the.
Okay. Well, in common law there is no pro se either. There's only there's a man and wrongdoer because pro se is a statutory term.
Okay.
Don't use their foreign language. What the heck is pro se? It's kind of like sounds like Spanish to me.
Okay.
Por favor, pro se. Más cerveza, pro se. Something like that.
Well,
you see what I'm talking about?
I see what you're talking about, but we trying to keep this judge from throwing this out. You
this judge is he's just an administrator with a wig and a cross dress on. I mean, he's actually, he should wear a rainbow flag to court, for crying out loud.
All right. Well, if I could get, the template or something like that, then I'm sure we could do some damage and have some news for you.
You give me a call tomorrow, and we'll see what we can do. Okay. Just give me a short email. So I have I'm pretty sure I have your contact information, Willie. But just send me an email so I have a reminder, and then we'll do it in the morning. Tonight I'll get flooded.
All right.
Okay.
Thank you very much.
Yeah, you got to stop speaking that Spanish to me, because my wife is Spanish, and she starts speaking Spanish real fast at me. That all I know is it means I'm in trouble.
Okay. Okay. All right. Well, peace to you.
Okay, brother.
Okay.
Take care.
Bye.
Okay. Let's see. Hang on a second. Hasn't hung up for me yet. Okay. Got somebody here from Illinois. Yes. Are you with us?
It's Richard.
Richard. Hi, how you doing, Richard?
Good. Hey, if I put in a bankruptcy a few years ago, lost the property in foreclosure, can I go after possessing that property again?
You put in a bank receipt, you said?
No, I did a bankruptcy in the past.
A bankruptcy, I'm sorry. Sorry, it was hard to hear. Okay, you did a BK, Chapter 13, 7?
7.
Okay.
And
7s are a lot tougher to recover from. Yeah.
I cannot recover from that?
Well, it's possible. It's always tougher after the fact, to be frank with you. But there's if they proceeded and it caused you harm and that forced you into bankruptcy, see, it's no longer about the piece of real estate, is it? Correct. It's about they trespassed on your property, causing you financial harm, which forced you into bankruptcy. That's your story. It's not about the real estate anymore. It's about your property being trespassed under fraud, probably. And therefore you had to lose it. Will you get the house back? No. Could you force them into some damages? You very likely could if they don't come and bring a first-hand material witness showing a contract that you originally had, and then it caused you harm. That's your whole case. That's it. It's not 90 pages. It's 1 page. And if they don't show up to bring forth the damaged party and the judge rules in your favor, well, actually you don't want the judge. You want a jury, because the jury is permanent, like in Article 7. Can't be reversed. That's why you always want a jury, so that way your judgment has standing. It won't be reversible or without prejudice or something like that. That's okay. You don't want to default. So you want to find out who you could bring forth who damaged you. That's the trick. Who is that?
That would be where the problem would be. How could I find out what bank? Because they switch banks so much.
Yeah. Well, who was the party in the judgment in the end?
This was done a few years ago. I have to go through records.
Go find out. And you can go after you can go after a corporation because you're a man. You're superior to them. But it's really better if you've got any individuals that participated in the scam, because I can tell you what, these trust companies, if you actually understand what they do, these trustees that sell these properties, they're buying that. They're buying that for pennies on the dollar, and they're selling that property and making a profit from it. They're just debt collectors.
One last quick question. I'm a driver. I work for the city, and the union has colluded with the city and forced insurance on me, a medical insurance.
Yeah.
And what they do is they pull $50 out of my check, my own personal belongings, without my consent. Even though the union say that they have the rulership over us because I'm part of a union.
Okay.
I don't believe they had followed they violated common law, I believe.
Well, when you join a union, I don't know if you joined it voluntarily or, like a lot of places, they try to force you into it. But
if you're not in it, you can't have the job.
Yeah, see, that's the ultimate statutory slavery right there. You don't have any rights at all. However, that doesn't mean you as a man don't have any rights. But I can assure you, if you want to fight that, you're going to fight it. You're going to be, they're going to make it tough on you. But yeah, when you join the union, supposedly they're to protect you. The reality is they're just making money off you. That's all unions do. We can argue that all day long, but that's the fact. They're just controlling.
Wouldn't they be under Amendment 4 that violated they went into my personal belongings and stole from me?
Say that again?
And Amendment 4, I believe it is, where it says the right of the people, particularly describing the place to be seized and the person or things to be seized. They didn't serve me any instructions from the law to go into my personal check, which is my personal belonging, and take money from me.
Well, and it's the union that's doing it. Well, you'll have to file a suit against the union. You understand that, right?
Right. I do.
Which is not a complicated thing to do. Once again, you can say, well, if you got the right, then show me the contract and bring forth the damaged party that's being harmed by my not doing this thing. That's all your case would be about. Once again, back to the same thing. Where's the contract? Where's the damaged party? And is it valid?
Okay.
If you want to proceed based upon that, it might be worth it. I don't know how much money that'd be worth to you over time, but you have to also weigh these things, whether it's a battle you want to fight. And it's not even a battle as far as I'm concerned. That's kind of what's cool about this stuff is that, in the Bible it says we're more than conquerors, which essentially means that as long as we put God on our side, we can't be beat, as long as, and it says in another part, we have our armor of God on. So in other words, we're confident, we're ready, we're shielded, we're protected, and we have authority. If you go into it like that, with that mindset, it really changes the way you look at it. But in this situation, with the way these guys play, they play dirty, so just be ready. I know a cop that in Southern California, he was the head of the union, and I won't say which jurisdiction, but he was the head of the union there, and he started asking questions about the whole thing about how are they actually following the law, and are they violating anybody's rights, and are they really just part of the whatever it was. I mean, he was questioning a few things, and they took that guy to town. I mean, they would show up in the middle of the night with doing raids on his house and just say, we're just kidding, and they were just messing around with him like that. They just harassed him. He finally won and they tried to get him off the police force. He stood his ground, and ultimately he won a suit against the police force, and he got 3 years of back pay because they told him they didn't fire him, but they said, well, you need to go on suspension. He says, well, I want it with pay because I'm right. So they ended up paying all his back pay, damages, and he got his job back and pension back because he stood his ground. So it can be done. But these guys, they're just thugs. They will play dirty, but that's okay. If not you, If not you, who's going to ever stand up to this stuff?
You took the word out of my mouth. Chicago is still filled with a lot of mafia that turned legal, and they're in.
Well, that needs to change, doesn't it?
Yeah, if it does, we need to force them to do what is right.
If the people don't stand up and enforce their rights, there is no republic. And the republic is 100% there when they do. That's what Benjamin Franklin was saying. It's up to you.
You mentioned Amendment 7, that according to the rules of the common law. The common law, that basically means, and then I'm off this call.
It was really hard to hear. The common law basically means what?
That's what I'm asking. Can you verify what the common law means, basically?
Well, actually, let's just say that the listeners, that some time they can go. Actually, there's a blog that talks about what common law is, the definitions, where it comes from.
Okay.
And I won't go into all that tonight. But the simplest answer I can give you is common sense.
Okay.
The only real law there is you did me, you hurt me, or you say I hurt you. Prove it. Let's go before the council, which is the jury, the people. Jury is the people, and let them decide.
All right. Thank you very much. I got it.
That's what it is. It's really that simple. Okay. All right, sir. Thank you. Okay, got a couple more callers on here. Somebody says, right, it's about the expense. Sometimes it's at the expense of your family and your mental health. Well, not if you do this right. I think that that's not the case. It's when you're in the defensive mode trying to fight in their world. It's really tough. It's insane, in fact. You're in the matrix. But I stood and I got thrown in jail, but one must be prepared to go that far. And I agree. I don't ever want anybody to have to do that. But I can tell you the guys that have ever been to jail come out so much more powerful. It's weird. While they're in jail, they're helping people out instead of going in there and crying. And, hopefully that was short-term for you, moxie. But you must have some moxie. I guess that's why you call yourself that, huh? Apostle Paul was in jail. There you go. Sometimes that's where you have to go to wake up. A lot of people don't wake up until it's too late, and then they're running in backwards, and that's why you can't win. You showed up to the football field with your defense only. All right, Southwestern Ohio. You're on. Hello? Are you with us?
Hello?
Maybe
are you able to hear me?
I hear you now.
Are you able to hear me? Okay. I am calling because I have a situation where I had a wreck in the state of Missouri. I'm from Ohio. I had a wreck in the state of Missouri, totaled my car completely out. And what I found out when the state trooper approached me in the hospital room, he said I did not have driving privileges in the state of Ohio. So he gave me a ticket or a citation, said I was driving under suspension, and there's a court date for October the 8th. I was thinking about going in with what's called a letter of retorgery. Are you familiar with that?
Say that word again. Letter of what?
A letter of, give me one moment, and I will spell it for you. I think it's spelled R-E-G-E, R-E-G-A-T-O-R-Y. And this is where...
Rogatory, okay. And what does that mean?
Well, it's, to my understanding, is where you're using the actual public defender to get the money off of your bond to settle the matter, because I guess I would be in an equity court and all they care about is contracts. Yeah. So you would be using the attorney as a private lawyer under the private international law. And so what you would do is provide this letter which instructs the attorney, the judge, the clerk of court as to what you wish for them to do and for them to remove the appearance bond. Does any of this sound familiar to you?
Sounds like statutory code stuff to me.
Okay.
It sounds to me like you ordered refried beans and a taco on top of a Big Mac.
Okay.
But
So
okay. Now I'm going to give you a suggestion. So now maybe listen, there are things you can do in the statutory courts and do, okay, if you understand what you're doing. But sometimes most people generally really don't. They're just throwing mud at the wall, and I don't recommend that. So how did that officer, if you were to demand to go to that, not to that court, but put a claim into that court and say, I've got a claim before this court, and I want you to bring forth the damaged party and put them on the witness stand, bring me a jury, and have them be convinced that there's a damaged party here.
Okay.
But doesn't that sound a lot easier?
It does, but I never knew how to go about doing it. Like I hear the people on the other call saying, hey, where's the template? What do I use? You know, people, we're like walking, we're straddling these two worlds. We're trying to grasp the new one, you know, and then we've always lived in the other one. So it's hard it's challenging to know what to say and not to use the words that pull you in under their jurisdiction. So if you and I were role-playing right now, this trooper gives me the citation. Now, I want to tell you there was no damage. There were no other cars on the highway. My car flipped over, hit a highway sign, landed upside down. The only damage was to my physical body, and my car was totaled out. So there was no damage to any property. There was no injured party. And the only thing he cited me for on this was driving under suspension, driving under suspension, which I wasn't aware that my driving privileges were suspended. So that's a whole nother thing that I have to address.
Again, that's driving and privileges. You just use statutory words. You have a right to travel freely.
Yes, I understand
as a woman. Can you tell me under what statute does it say that a man or woman cannot drive and travel, so cannot travel freely?
Cannot travel. It does not say that under any type of statutory information, but I've allowed myself to come under the license, and I've signed on that, and I've signed up for that contract that I didn't even see, which was still, non-disclosure when I signed for my driver's license?
Yeah.
So I don't know how to. Go ahead.
Well, somebody's popping up on the window. Very good point. That if you say that to a cop, they're going to say you're a sovereign citizen. I'm going to say, well, are you ordering me to be a sovereign citizen? Always answer a question with a question like that. Because there is no such thing. There is no such thing. But the other issue, if you were addressing the cop at that moment, what you could have done, try put the letter NA after your signature on a ticket. Okay?
Okay.
NA means non-assumptive. It means I don't assume liability.
I did that before, too.
Okay. And when you go to court, say, can you show me the ticket with my signature on it? No? Well, because according to this, there is no signature, because non-assumptive essentially is like an invisible signature. Okay.
So,
but then you can flip it right back around and go file a claim on them if they want to pursue it.
Okay. So this is what I'm not certain on how to proceed. So this court date is coming up, October the 8th. Instinctively, I want to get an attorney because that's all I know. But I know not to get it because I'm going to lose, and I'm going to have to owe a lot of money and come under their jurisdiction and their punishments or whatever they issue, fines, citations, whatever they issue. So this date is coming up, October the 8th.
Okay.
I submit a claim saying provide me with the injured party.
You give them a notice. First, you give them a notice and see. Somebody has accused me of causing them a harm. Please bring forth the damaged party so that I can remedy this with them, something like that.
Okay.
And if you cannot bring forth the damaged party and you continue with this, I'm going to bill you, the court or the police officer or whoever, X amount of dollars for continuing to pursue a false claim.
Okay.
That's it.
Okay.
That's your cover letter. I mean, that's your notice.
Okay.
Now, then you say, now, as a result, I think we need to reschedule that date while you consider this matter. And then essentially you're just going to buy some time.
Okay.
And then you go to the next thing is if they don't cease and desist and withdraw the case, and that's what you're telling them to do, then you file your claim and you notice those parties. And tell them to show up in 21 days, and I'll have a jury there to see who the damaged party is. They probably will want you to go away at that point.
Okay. So how do I request a jury? How do I request that? I'm kind of missing how you do that. Okay, so I'm sending this notice.
Okay. I'll just kind of, let me see if I can get one up here on the screen.
Okay.
I'm going to try to read you somewhat. You can word this any way you want. I mean, these are just kind of off a current case having to do with foreclosure. It doesn't matter with the foreclosure or any agency or whatever claim. Just my computer's
I have one of those too. I'm in appeals today. I went to an appeals hearing today for the foreclosure that I'm in.
How come you're not paying? How come you're not paying your mortgage?
What mortgage?
Gotcha. I was just trying to mess with you. Okay. This is what I do to my people I help all the time. I drill and test them.
Did I pass?
That's what the judge is going to do anyway. You say,
Did I
what
pass?
mortgage? Are you claiming I own a mortgage? Well, you could have said, you answered the question. That's good enough. Or you could have said, well, you're alleging that I owe a mortgage. I'd like somebody to come prove it.
Okay.
Just always ask a question. Just getting it. You tell your kids, listen, this is what we've done. We've brainwashed our kids to do this. We tell our kids, don't answer a question with a question. When in actually you should be telling them, you better answer a question with a question if you're going to protect yourself in life.
You're speaking in parables.
Exactly. So here, let me read one to you.
Okay.
Okay. And this is nice. This won't take long because this is how long my suit is. In county court at Superior Court of Arizona, Maricopa County. Now that's not the Circuit Court of Maricopa County. I didn't use that, none of that of stuff, because of means you're a slave too. No, I'm in Circuit Court at Superior Court of Maricopa County. So I retitled the court, and that they'll recognize that as meaning you're talking about a common law court now. Then I, a woman, prosecutor. My name's not on there. It's just I, a woman, prosecutor. Not plaintiff, prosecutor. That's a common law term.
Okay.
And then it says nature of the case over on the right, claim, trespass, theft, verified. I'm not putting a bunch of long words, anything complicated. It's a claim, trespass, and theft. And then then below on the left side, where you have your plaintiff and defendant, it's not plaintiff and defendant. It's I, woman, prosecutor. Then below that it says, I'll just use Smith, James Smith, wrongdoer. Wrongdoer is a very serious charge, actually.
Okay.
And then it says how it was filed. If there's and if you take it to the courthouse and they record it, they'll stamp it, and you can leave this next part blank. But I tell people this: when you're sending your claim in, if you have any resistance to recording it, and you should not, if you kept it simple, they'll record it, and that's the end of it. Now you got a stamped copy that you can take around and send to those people and say, "Hey, I filed this. Get ready," Or if they give you resistance, send it registered mail, not certified, registered.
Right, registered. Mm-hmm.
Because they're forced to acknowledge its existence, and it becomes a registered document when they receive it. People haven't tried to get around these recorders. This is how you do it.
Okay.
Then you say I, lowercase I, common, Jane M. Smith, require, a court of record, in quotations, semicolon, trial by jury. Trial by jury, as in Article what?
7. Wait
7.
a minute.
There you go.
I thought that was amendment.
Amendment 7, yes, correction. I said it wrong. So you caught me on my words. Good. So Amendment 7, trial by jury, a court of record means common law court. You don't say common law court. A court of record is a common law court. You can look this up on the website of the U.S. District Courts. Then claim, trespass, theft. Okay? And then it goes into I, Jane M. Smith, a woman, claim. Said wrongdoers trespass upon my property and are attempting to administer the property without the right of contract. That's the main part of what you're going to say. Said wrongdoers trespass on my property and are attempting to administer property without right of contract. Guess what? You think yours is a traffic case? No. They're trespassing upon your property by trying to take something from you.
Okay.
And are attempting to administer your property without right of contract.
And what they're attempting to take from me is my compensation for my labor?
Yeah.
Okay.
Your time, your labor, your energy, your ability to exist in commerce, by not letting you drive or whatever they call it. Okay. Yeah. Then now in this case, I put reference case number, then it says CV, and what I'm referring to is in this case, there's an existing case number. So I add that in as a reference only.
Oh, okay.
I'm not citing the case, I'm referencing it. Because in other words, that case is part of the cause.
Yes, reference case number. Don't cite it because then that's using statutory language.
Exactly. And the other reason you put it in there so that when you get this recorded and stamped and all that stuff, you're going to walk over to that other court and you're going to hand them this and say, please enter this into my case. And now you're showing a claim on top of their case. That doesn't slow them down nothing well.
Okay. Claim on
then
top.
Next bullet point: the trespass did and does harm and injury to my injury to my property. Let me say that again. The trespass did and does harm and injury to my property.
The trespass did and does harm.
Yeah. And then you could say the next line. These are all lower capital. We don't use capital letters anything in any of this because that's all proper statutory use. Okay, the commencement of the wrong and harm began on whatever date. So that could be the date that they gave you the ticket.
August the 21st.
Okay, the wrong and the harm continues to this day, which is today's date.
These are all bullet points.
Mm-hmm.
I, require compensation for the initial and continual trespass on my property. Semicolon.
Okay.
So you're saying now you're starting to create a bill, because you can't have a claim unless there's a bill. There's got to be a dollar amount associated with it. So then it says compensation due, value of property taken. And in this case, it was a foreclosure situation. And then they say they put in $400,000 plus damages of $10,000 per day until property is returned, free of encumbrances by any of the parties alleging a claim.
Okay, so
look at the words I'm using.
Okay, go ahead. Say that once more.
Well, this is kind of a foreclosure. Compensation due in your case could be, hey, I don't know what it's going to be. You have to come up with a formula and make it reasonable. I mean, this is bigger because they already took the property, but what they're trying to take from you is your ability to conduct commerce and other things. Make it simple. I mean, they're saying you owe them X amount of dollars. Well, fraud is triple damages right off the bat. So you could say triple damages of whatever their claim is, plus $1,000 a day that they continue to make that claim without proving their claim.
Okay. Now, so that's for the foreclosure. That's for the bill for the foreclosure. They haven't been able to get me out of my house. I'm sitting here in my house. I haven't paid a mortgage since 2009, and I'm sitting here in my house now. So I did the appeal today. I'm waiting for the outcome of that. So while that's going on, do I use do I place a claim over top of what this attorney is already doing?
Do you want to keep running backwards? How long do you keep running backwards?
I don't.
Well, you say something about an attorney. You have an attorney doing something with you in your foreclosure?
Yeah, I have an attorney. Yeah, the attorney has, because they, somehow they ended up getting a summary judgment against me, and I didn't know what to do. I didn't know what to do.
A summary judgment is weak at best because it means you didn't show. It doesn't mean they proved anything.
They didn't, and that's what she gave the points today. And
so, what I would be doing, they're just still playing defense. Your offense is still out there having lunch at the tailgate or out in the parking lot.
Okay.
You got to file a claim to move it forward.
Okay.
Okay. And now the last line is you have 21 days from the date of receipt to respond and produce the specific damaged party verified contract. Verified means on the witness stand verified, along with proof of specific debts and amounts due, so that I, woman, and prosecutor can attempt to settle this matter prior to proceeding with this claim in a court of record. Again, that's common law right out of Article 4. Okay? Then I, Jane Smith, say here and will verify upon an open court that all herein is true. In other words, you're saying, I'll get on the stand. See, you're credible now. You're the honorable one.
Okay.
Then there's a signature, and then you just don't put your name below it. You just actually put your fingerprint below that in red ink.
Wow. Red ink fingerprint. Okay.
Well, you sign, but then you red ink fingerprint because only a man can sign with his blood signature.
Okay. Okay. So what is this about the stamp on the back of your court documents down in the corner, and you sign through it with a gold ink pen? Have you heard of any of this information?
Yeah, I've never seen that it has any purpose other than to sound really cool, like you know something.
Well, I heard that it pulls you under the UPU, the United Postal Union.
Yeah.
Yeah.
And is a man, listen, go back to the beginning of time. Did a man have to use the UPU to get his rights held in the court, the common law court?
No, the man didn't.
Nor
the woman. Okay.
So, you got it? You see, that's see how easily you get pulled into that what I call that sort of stuff? Yeah.
Okay.
It might be useful in some very slight cases. I could use that stuff. I don't see a purpose for it here.
Okay, so this isn't something I have to talk over with my attorney. I just do this and go file a claim.
The attorney's going to tell you you're smoking something you learned something from some guy on the internet. That's what he's going to tell you.
Okay. And so what does that do? Does that make the attorney say, look, we're not doing this? does that
no, first
make
of
it
all,
where I'm...
First of all, your attorney still does work for you, but when you're in the court, you can't speak. Only he can speak there because you're a foreigner in the court. That's why you can't speak.
Right.
But outside of that, you can tell your attorney anything you want. And I would tell him, I'm going to file this claim, and here's why. If you want to help me with this, great. If you don't get it, you're not on. You want to change one word of this thing, and you don't agree with it. It's up to you. Then you'd like to just say, I'm going to proceed with this path on my own. Because I tell you what, if you're under an attorney, you can't speak.
Okay.
You
now,
are
what
speaking
about?
here.
Okay. I understand that. And so this works for the same driving without privileges in the state of Missouri.
It doesn't matter if it's some agent coming after you. It doesn't matter if it's saying that you owe them some sort of money. It doesn't matter. It doesn't matter. All you're doing is saying, I'm giving you opportunity to prove your claim through a due process.
Okay, due process. Okay.
You don't get somebody due process, then you will fail. Matthew 15, 16 through 18.
Matthew 15, 16 through 18.
Yep. That establishes what is due process, and if you violate it, all hell breaks loose. And I can tell you, I've seen that so many times, it makes me, every time I see somebody doing it, I go, here we go.
Wow.
God will serve this thing up every time.
Okay. So I'm filing a claim plus my bill, and I'm submitting that to the court, giving them the time to answer. If they don't answer, then I'm requesting trial by jury.
You said it right the first time. Require. A man requires of his servants, public servants. He doesn't request.
Okay. Require.
You don't demand. You require. The word is very critical on that one.
Okay. All right. I appreciate your time. And then what else do I do about getting out of this hole? I don't have driving privileges still.
Privileges? It sounds like something Caesar gives you.
I know. So how do I unadhere myself to these adhesion contracts that I've gotten myself entangled in?
That's irrelevant.
License.
If it were me, and I'm not telling you what to do, for me, I'd get in my car and go someplace if I need to. I'm traveling freely. Somebody wants to ask you a question. I know it's difficult because people say, they'll tase you or something, and say, show me in the law where it says I cannot travel freely.
Well, I did get pulled over. Yeah, I did get pulled over again after the accident because I did jump in my car and go. I traveled to earn compensation. So I was traveling in another part of the country. I got pulled over in Texas, and I went back and forth with the officer, not arguing. I said, who are you? I don't know who you are. Show me some information. Why are you pulling me over? They kept saying, show me your information, then I'll tell you why I'm pulling you over. This went on for about 30 minutes. Eventually, I'm serious. Eventually, I got out the car, gave him my insurance, and eventually gave him my driver's license. Now, had he ran that through, then the car that I was in would have been towed, and I guess I would have been carted off to jail, which he did threaten jail. I said, I still don't know who you are. So you need to, so it was more for me, who in the world are you? I don't know you from a can of paint. So we kind of went back and forth on that. And then eventually he let me go, which means he just didn't run my license through. Had he ran them, then he would have saw.
Once you had it in your license, you created a contract. So the easiest thing to do is just say, if you want to, there's a couple of ways to handle this. There's no one way for everybody. It depends on how confident you are. But if you ask a question, say, please provide me the law that tells me what I'm required to give you. Don't say yes, no, maybe. Just please provide me the law, and go. And secondly, bring back your oath of office with you as well. You need to have that on you. And if they don't, anything they do after that point, they're completely violating their oath of office at that point.
Okay.
If you ask those questions, you would then go ahead and take the ticket, write NA on the ticket, and then deal with it with the court if you have to. Don't confront them. I don't want you to do that, but you have a right to ask questions.
Yeah, because he was screaming. He was saying, roll down the window. I said, I'm not rolling down the window. I can hear you through the sunroof. And he said, roll down the window. He kept demanding it,
They would ask me, is that an order? Because a public servant can't order a man what to do.
Okay, and he told me to hang up my phone. I told him I'm not hanging up my phone. I said, who are you? He said, I'm a peace officer. That's what he said.
Show me your oath of office so I can identify you, and that I know that you're protecting the rights of the people.
Okay. Got it.
Okay.
Got it. Yes, I'm there.
All right.
Got it. Thank you.
Okay. Well, what have I just been telling you? You should be able to tell me by now.
Well, who's making the claim? Is that one of them?
Yeah, you've sent them a letter saying, I see you got all these things here you call tickets. Somebody's alleging I owe a debt. Please bring forth the damaged party so I can have an opportunity to work it out with them. If not, I'm going to file a claim against whoever's making that claim. That's it. Right. It's the same process over and over again.
Yeah, but the thing is, it's hard to find somebody, the DMV, that's making the claim. As far as the person that signed the signature, it's always a DMV. I mean, there's no name. There's no party, no injured party. It's just computer printout.
Yeah. Again, write them a letter. Say, who's the man or woman I can talk to about this? Call them up. I bet if it says I have all these tickets, they're saying I owe all this debt. They're saying you owe a debt. So where's the proof of the claim? And I need to know who I can contact about this.
Okay.
And if you got to call them, say, is there somebody called Mr. DMV that I can talk to?
Okay.
Because apparently they say that I owe them a debt. I just want to find out who that is.
Right.
Put it down as best you can and order somebody. They'll send an attorney is what they'll do. And you'll say, well, do you have first-hand material knowledge that I committed any of these problems and that I've damaged a party and that there's actually a valid claim anywhere? Oh, no, you can't? Your Honor, would you please tell him to sit down? That's what you do.
Right.
You can't speak.
Okay.
That's the only rule of your court. And then you get a claim against them, and you just say, well, I order all this stuff you wiped off the record.
Mm-hmm. Because I haven't had any new tickets in the last 7 years. I mean, every time I'm here in New York.
About time, man. What are you doing out there? You're running around and, speeding and running stop signs and scaring children? What is that?
Yeah, I was young, so I did.
But that's all you do. It's the same thing. Find out who it is, send them a letter, and then send them a claim.
Okay? Yeah, I'll do that. Okay.
All right. I'm going to rapid fire through a couple more calls. We got a few still on here, so please make them as quick as you can. We're running along. I know we could do this all night, but I don't want to. I want to eat dinner too.
Hello?
All right, go ahead.
Can you hear me?
Yep.
Got a situation that I got to go to court, PK court tomorrow. About a year ago, I had filed a PK-7, and I filed a motion to dismiss. And trustee filed, if it is dismissed with prejudice, not able to file for 3 years. Well, a year and a half later, I filed a 13. And tomorrow morning is a hearing to dismiss that based off the previous one said not able to file for 3 years. But the new motion is to say that it will be able to file for 5 years. And what I want to know is, can I go in there tomorrow and switch this by Amendment 7, ask for trial by jury?
You're in the middle of big K courts are really tricky, and I don't pretend to be an expert on them. I only just talk about common law. But you can go in there and ask anything you want as long as you understand what you're trying to do. In a BK court is this, though. It is a claims court. That's what's going on. So you're holding off your people that allege you owe them a debt. They'll send in a B-10 form. You probably recognize that.
All right.
They say, well, everybody submit your claims. And then they all put their claims in B-10. And you go, yeah, that's the guy I owe. Oh, you just confirmed that one. Yeah, that's the guy I owe. Oh, you just confirmed that one. Right? And so you've already validated so much stuff when you go into BK court. Now, doesn't mean it's the end of the road, but you just got to understand why you're in the situation you're in.
Okay. Let me throw this part in there. and you'll see why. I only filed it to hold off a writ of possession for foreclosure done in 2011.
Okay.
I'm currently
Okay.
at home.
So what I would do is let them throw the thing out.
Okay. That's
just maybe you need to just get the heck out of there. You know, sometimes you can't get rid of the stink out of a box that a cat's gotten in and pissed in, right?
Right.
You just, you can't get rid of that thing. So what you do is say, okay, look, I'm going to just put this aside. The only thing that's going to happen is they're going to maybe reinitiate a foreclosure process, if anything. So then you immediately go back after the lender for their claim. Where's the man making the claim? If he can't come forward, you're playing the ultimate defensive game. When have you ever brought the offense onto the field?
Well, that's
they're still eating hot dogs in the parking lot, aren't they?
That's what I want to do. I want to file a claim.
So,
if I file a claim in the court I don't even know which court that was awarded the foreclosure.
You don't?
Well, I mean, it says county court.
I mean, it probably was a judgment, right?
Right.
So to get that judgment, it's going to say right on there who it was, who the party was awarded some damage, and that's probably who you have to start with.
Okay.
And the parties that participated in it. You say you're still putting forward this claim that I owe an alleged debt, but you've never brought forward a proper proof of claim.
Now,
you put a B-10 form, you put a piece of paper into a court. But a proper claim is made under Amendment 7. Suits in common law where the value of controversy shall exceed $20, the right of trial by jury shall be preserved. Let me ask you, have you ever been in front of a jury with this whole case?
No. Never.
Well, what do you know? So in other words, you might have a void claim. They might have a void claim. So no fact tried by jury shall be otherwise re-examined by any court. So what does that mean? It means if you win there, you got a permanent judgment against them, and there's no place they can go. They can't hide, they can't run, and now you got a negotiable instrument to negotiate with. You say, tell you what I'll do. Let's just drop this whole thing, or you can go ahead and pay me. Which do you want to do?
Okay. Now, the original servicer that did the foreclosure is no longer in business, and it was sold to a new, which is Aquin now.
Well, let somebody come forward and make a claim. That's okay, fine. Oh, you're the guy now? Great, come on in.
Okay, good. Okay.
Because it isn't about the bankruptcy. It's not about the previous thing. It's about who wants to make a claim. Oh, really? Okay, here's how this works.
Okay.
Notice, file a claim.
Go through and let them do that.
Let them do their thing. Let them come. Listen, a lot of this is about what I call drawing them out. Mm-hmm. You don't draw them out, you don't know who you're going to shoot at, right?
Right.
So you got to draw them out.
Okay.
So draw them out.
And is it okay if I draft it, email it to you, let you see it, see if it's worded correctly?
Well, we'll talk about. Maybe we should talk one-on-one, see what you're trying to do. Because if it doesn't make sense to me, I can't guarantee I can get back to every email.
Right.
I'm working a lot with a lot of our donor clients and things,
right.
so I can't put them behind you. But I certainly will. If I see something, I can look at it. But there's definitely a right way to word it with specifics that you want to do. There's a format. Okay.
Okay. Perfect. I appreciate it.
You bet. Good luck. You're gonna be all right. You just hang in there.
All right.
Okay, we get somebody on the Central Coast of California. I think we've already had you.
Yeah, you have. I just thought you said some amazing things to that lady in Illinois, and you were talking a little bit about people who have already had their properties foreclosed on, and you said your claim can work. Can it work if you're in one state and your property was in another? Does it work also if you you were forced into a short sale because you didn't know any better at that time and you were told, you had to short sale it?
Let me ask you a question. Where is your property?
The property at that time was in Tennessee, and obviously I'm in California.
Yeah, I just played a judge trick on you. You didn't answer my question. You thought you heard me ask you where is the piece of real estate. What I said is, where is your property? Your property is wherever you are.
Okay.
Your property is wherever you are.
So I'm here in California. I can bring a claim right here for the violations they did against me when they took my form of income.
That's one way you can do it. I'm not telling you there's one way to do it. I'm just telling you to understand the logic of why you're doing it that way so you can back it up. There's more than one way to do this stuff.
Yeah.
Okay? Sometimes it's done through the statutory courts, but I don't recommend it.
Is there a statute of limitations to doing this?
There's no statute of limitations in common law. There's only statute of limitations in the statutes. Listen to you couldn't get more obvious than, is it a statute? If it's a statute of limitation.
Okay, great. That's answered my question, because I will be coming to you when I have a little time to do all this, because I have 7 of those.
Wow. Okay. Well, pick one and start there, and I'm sure after you've done 1 or 2, maybe with some help, then you'll be on your own. You're capable of doing it. It's
great. Thank you very much. That's all I needed.
Okay,
You gave some great information to that lady. It was really interesting to listen to.
Oh, thank you. Thank you. Well, I'm just, I don't take responsibility. You may not believe this, but I don't take responsibility for the words I speak at all.
Oh, well, that's okay. It's, we're learning. We're learning.
I believe God's behind this, and that's what we're trying to do.
Yeah, I think so. Yeah. Okay. Thanks for the info. Bye-bye.
All right, man. Take care. Nice talking to you. Okay. Any others in the queue? And I don't think so. Wow. Big call tonight. So, listen, I appreciate everybody being here. Lots of stuff to cover. Tomorrow, I'm planning on sending out an email tonight to a smaller group of people. If you're working on your cases, I'd like you to get on that call if you can. It'll be noon Pacific time. If nobody shows up, great. But if you are, or you have more detailed questions, if you have registered right now, if you just registered on our website, I'll just send it only to that list, the number, probably about an hour before the call at noon Pacific time. And then I will take more detailed questions. And those of you who are working with, and you have the documents that we're helping you draft, because we actually assist with you're really drafting it, but I'm just giving you a starting point and then explaining to you why you're doing it. So you have the not what to do, but the why you're doing it in your head before you do it. That's when you have power. So I want to make sure we cover that. We'll even do some role playing on that call, and I got a couple other surprises as well. Everybody else, if you haven't gotten involved with the Bitcoin program, the BitClub Network, bitclubnet.com, go grab a free spot and check it out and see if you want to proceed with that. I assure you, one way out of this whole problem is to stop using their currency. And I'm not the only person in the world saying that. There's millions that are doing it already. Whether we do it or not, it's going to happen. So that's something you got to focus on too. You want your republic, though? We don't have to throw out the whole system. We'll train the courts how to treat us by coming in the court the right way. That's how you get your liberty. Okay? You already have it. You just got to use it. So anyway, until next time, folks, see you then.